Today, we're diving into a legal fight that really pulls back the curtain on a conflict brewing inside a quiet Arizona condo community. It's a story about one homeowner, his HOA, and a battle over meetings that just never happened, records that were never shared, and a board accused of just holding on to power. And it all kicks off with one heck of a claim.
Wow. Okay, so this is the claim right at the heart of our story. It comes directly from a petition filed by a homeowner named John W. Gray against his HOA. And that single sentence, it sparked an official hearing, and it basically put one resident's demand for accountability right up against his community's leadership. So let's set the scene. On May 15th, 2023, Mr. Gray files that petition, officially setting the stage for a legal showdown. Now, he wasn't just vaguely upset. No, he laid out a very specific case built on three central allegations against the board.
His complaint really rested on three big pillars. First, the HOA had just gone completely silent. They hadn't held an annual meeting for 3 years straight. He argued that this led directly to the second problem. The board itself was illegitimate because they had basically appointed themselves to stay in power. And third, to top it all off, there was just a wall of silence. His requests for basic community records were being systematically ignored.
Now, here's where this case gets really interesting. The HOA didn't really dispute the facts. I mean, their own lawyer said, the facts are the facts. We don't change the facts. So instead, their entire defense was about the why. It was a defense that leaned really heavily on the COVID-19 pandemic and, well, what they called a longstanding problem of homeowner indifference.
What's pretty wild is that both sides completely agreed on this basic timeline. For 3 full years, right at the height of the pandemic and its aftermath, no annual meetings. Nothing. It wasn't until July 2023, after Mr. Gray had already filed his petition, that a meeting finally happened. So the big question for the judge was there a legally valid reason for this 3-year gap? And this really gets to the core of the disagreement. On one side, you have the HOA saying, hey, look, we were in a global health crisis. Canceling in-person meetings was a necessary precaution. Their community manager even testified that she was COVID compromised. But Mr. Gray's comeback was pretty simple. Remote options like GoToMeeting were everywhere. They were cheap, and for a community with a ton of absentee owners, maybe they should have been doing that anyway. So then the HOA added another layer to their defense: homeowner apathy. Their lawyer argued that even before the pandemic, they had a really hard time getting a quorum. That's the minimum number of homeowners you need to show up to hold an official vote. They basically claimed that even if they had tried to hold a meeting, it was a pretty safe bet that nobody would have shown up, just like what happened back in 2019.
This brings us to Mr. Gray's most serious charge, that the board running his community was illegitimate. His argument was that with no elections for 5 years, these board members had no right to be in office. The HOA, on the other hand, argued they weren't just making up the rules as they went along, they were actually following them.
Okay, so the HOA's entire defense pretty much hinged on this one powerful little phrase in their own bylaws. It says, directors have a 1-year term or they serve until their successors are elected and qualified. That little "or" clause, it became the entire foundation of their legal argument.
And get this, it wasn't just in their bylaws. The HOA's lawyer pointed out that Arizona's state law has almost the exact same language. The law itself says that even if a director's term is up, they shall continue to hold office until a successor is actually elected. This is a legal concept called by operation of law. Basically, the HOA's argument was that the board members didn't actively decide to extend their own terms. Instead, the law and the bylaws did it for them, automatically. Since no elections could be held, first because of no quorum, then because of the pandemic, the existing directors were legally required to just stay in their roles.
But remember, this wasn't just about who was in charge. It was about transparency. Mr. Gray also laid out a long, frustrating paper trail of him just trying to get the most basic information from his HOA. I mean, look at this. He documented a series of requests that stretched over almost 2 years. He was asking for budgets, meeting notices, a list of who was even on the board. And then he made this huge request for nearly a decade's worth of invoices for the fire sprinkler system. And, for the most part, he testified, his requests were just met with total silence. So when the community manager was asked about this, she said that getting all those records together, especially the sprinkler invoices going all the way back to 2014, was just very time-consuming.
She also said she wasn't even sure if all those old records still existed, but she did say she was still working on it.
So after a full day of testimony and arguments, the judge had to rule on these three key issues. And the final decision, which came down on September 20th, 2023, was not a clean sweep for anyone. It was a classic split decision.
Okay, let's break down the verdict. On the first issue, the missed meetings, the judge sided with the HOA. Why? Because a meeting had finally been held in July 2023, making the whole issue moot or no longer relevant. On the third issue, the board's legitimacy, the judge also sided with the HOA, agreeing that the law allowed them to keep serving. But on that second issue, the fight for records, the judge ruled decisively for the homeowner, Mr. Gray. And because Mr. Gray won on that really crucial records issue, the judge decided he was the prevailing party. The result? The HOA was ordered to pay back his $500 filing fee. It's a small amount, sure, but it was a really symbolic victory for transparency. At the end of the day, the judge's decision painted a really interesting picture. The board's power? Yeah, that was legitimate under the law. But their practices, especially their lack of transparency, were not. So while they had the legal authority to govern, they had pretty much failed in their duty to keep the residents in the loop. Ultimately, this case leaves us with a fascinating question that goes way beyond just one condo complex in Arizona. It really forces us to ask, what's the right balance between following the strict rules and, adapting to a crazy, unprecedented situation? And for any community, big or small, what's more important, the legitimacy of power or the transparency with which that power is used?